Good afternoon, and thank you for joining us. My name is Kristen Marie, and I serve as AHOA's Education Manager. As the association continues to fuel hotel owners with resources, we're pleased to welcome back Stephen Shapiro from American University Washington College of Law, along with Emil Hirsch from Carleton Fields and Daniel Lesser from LW Hospitality Advisors. In this session, they will discuss about the possibility of receiverships and the task of working with a qualified and experienced receiver that can be essential for success. Before handing this over to Stephen, please take note of the following disclaimer. There will be a Q&A available at the end of the conclusion of this presentation for any questions you may have. Please type them into the question section on your screen. Take advantage of this opportunity to ask what's on your mind, and we will do our best to answer as many questions as possible. Today's webinar will also be available for viewing within 24 hours on our COVID-19 research page at ahoa.com. We're excited to have you here today. So with no further delay, I welcome Stephen to begin.
Great, Kristen, thanks so much for having us again. It's a great relationship we have with AHOA, and we certainly admire the work of AHOA and the work of the members, and also happy St. Patrick's Day to everybody. Dan and Emil, thanks for joining. Our topic today is receivership. I look at it, and we look at it from two different angles. One is for the AHOA members who are facing stressed properties, maybe getting some correspondence from your lenders and wondering what's going to happen, what can happen, what are the alternatives. And then also with that, are there opportunities? If a hotel is in receivership in your town, are there opportunities for AHOA members to get involved and to participate? We have Dan Lesser, as Kristen mentioned, a great friend, colleague, and advisor, founder, CEO of LWHA. I'll let him describe his company, but for me, an incredible leader in hospitality in the US. Great experience, wisdom, and great at community building. Emil Hirsch, an attorney, partner in Washington, D.C., who is the guy, whenever I have a friend, colleague who's in stress, I say, go talk to Emil. Emil, let's set up the platform. Property that's in stress, lender may want to take the property. Give us some of the options, and you can, if you want, first say hello to our listeners.
Hello, everyone. I'm Emil Hirsch. I'd like to basically explain to you, for starters, what a receivership is. A receivership is an equitable remedy. It's a court remedy. It doesn't exist outside of a court system, or at least I've never seen one. So one has to go to a court that has jurisdiction over an entity or over a hotel property in order to get a receivership. The receivership is an interim remedy. It is not meant and is never permanent. There's no such thing as a permanent receivership. And if you gave me a limitation of one word to describe what a receivership does, or what it does is it affects control. So the one word would be control. It takes the control of the property, but not the ownership, away from the owners, and it shifts it to this entity called the receiver, which is an officer of the court. So the possession of the property is in the hands of the law. The officer of the law who's appointed, an individual like Mr. Lesser, who has the qualifications and the experience to run it. He is the arm of the law, and while the property is in receivership, the owners do not have control or possession of it. The receiver does.
Let's take one step back, Emil. We have a lender who is unhappy because loan is not getting serviced. We have the borrower, the hotel owner. Who makes the initiative to appoint a receiver? Is it the lender? Is it the hotel owner borrower, or is it somebody else?
Okay. In a situation like you gave, the hypothetical you were clearly the secure creditor, the lender, has the standing and the right to petition a court without anyone else's concurrence to put a receiver in. Other stakeholders who have the standing and the ability to petition the court for a receiver, it could be the government in certain situations. Let's suppose that the property is one that has numerous building code violations, which come to the attention of the local authority. There are receiverships like that. The only other entities that have the right to petition would be owners. In other words, a shareholder, a unit owner in an LLC, a general partner. Usually it is an owner who's not in control, who wants to shift the control to a neutral, someone like Mr. Lesser, who would then wear the mantle of a court-appointed receiver. So that's the universe of who can petition for receivership.
Great. Dan, thanks for joining us. Still on background, Dan, the classic for a bank is to say, in a sense, the heck with this. We have a failing property. We're going to foreclose. We're going to auction this thing off, and we're going to hope for the best. That's the classic traditional model. This is something else. Can you walk us through option A and option B, A being foreclosure and B being receivership, and why receivership makes more sense in a hotel environment?
Great. Well, Steve, thank you for the invite to participate. And Emil, I have to tell you that you are very articulate on this topic, because I've been on many presentations dealing with receivership, and you explain it very nicely. So thank you. Steve, if I could just take a moment about LW Hospitality Advisors. We are a hotel-centric consulting, advisory, valuation, feasibility firm. We have several silos of business. The first silo is valuation advisory services, which encompasses appraisals, market studies, feasibility studies, expert witness related work. I do a fair amount of testimony. I also serve as an arbitrator in connection with disputes. The second silo is asset management, and we do traditional hotel asset management. We have about 20 hotels in our portfolio that we oversee day-to-day operators. We also, within that silo, have cultivated an interesting cadre of clients who we very respectfully refer to as newbies to the hotel space. So smart, sophisticated folks that know what they're doing, but don't really know hotels, and so we help them on that side of it. And then the third sub-silo within asset management is receivership. And as you gentlemen know, I'm currently the court-appointed receiver of a fairly sizable portfolio of assets around the country. It's almost 50 properties throughout the United States. So it's really been a tremendous experience that I'm happy to talk further about. The last silo that I'll just mention is a platform called Lodging Analytics Research and Consulting. It's a predictive analytics platform. Amazing product. If anybody is interested, I'm happy to talk to you offline about it. So coming back to the situation that you pose, Stephen. Listen, it's a troubled asset, and the lender and by extension, what a receiver has to do is it's all about collateral and preservation of the collateral, right? At a very minimum, preserving cash flow, preserving value, right? To the extent that during some control period for a receiver to increase value, well, that's just fine. But the main goal is to preserve collateral value. And so a lender, looking at a troubled asset for many reasons may not want to follow through with a foreclosure process and take title to a property for a whole slew of potential reasons. In which case they will want to get control of the asset, remove the owner from day-to-day control. But as Mr. Hirsch said, they're still the owner, right? But they don't have control. And then what they would do is appoint or go to court to attempt to appoint a receiver. I would like to just, if I can, expand for a moment on
Sure.
Emil's commentary. It's interesting. You would think that the qualifications for a receiver should meet a fairly high standard. The reality is it's a very low bar. Frankly, if you're alive, you're walking and you're breathing, you can be a receiver. If you're not a convicted felon and stuff like that, but ultimately, it's up to a judge to appoint a receiver. And I can tell you that I was recently involved in a situation whereby all the parties, from the lender to the operator to the owner, agreed that they wanted me to be appointed as the receiver. And the parties went before a judge who said, well, I actually have the right individual for this. He happens to be right down the block. This gentleman was an attorney, one person in a two-man firm. They did estate planning for elderly folks. That was their experience, and they were appointed. He was appointed receiver of a several hundred-room property hotel. Not qualified at all, but friend of the judge. He ran the judge's prior campaign. And what's even more interesting is that I came to learn that he appointed his partner. Again, remember, these folks do estate planning. He appointed his partner as outside counsel for the receivership estate. So, a little bit mind-boggling, but those are the facts, right? And apparently it's all legal too. So just wanted to expand a little bit further on Emil's great description.
Great. We'll come back to you about the work of the receiver. Emil, for a moment, in a classic foreclosure, the bank comes in and not in a sense, but legally wipes out the owner and stands in place, or the successor stands in place of the owner. In a receivership, Emil, as Dan mentioned, the owner is still around, and you're also talking about cash flow. Whether you represent the bank, Emil, or the hotel owner, borrower, debtor, how do you preserve those relationships, and how do you advocate on behalf of your clients on either side?
Okay, well, there's a big difference when I represent the owner, and there's a big difference when I represent either a secured creditor or some other stakeholder who has the right to be a petitioning party for the appointment of a receiver. When I represent a lender, the goal is very, very focused. The goal is to preserve value, as Dan said. It is to preserve operations with a minimum of disruption. And in order to achieve that, you have to achieve control, okay? Because you cannot preserve value without having control, because control gives you two things. It gives you the ability to control what happens to the room revenue as it comes in, and who controls the room revenue and how it's applied is vital to preservation of value. And the other aspect of seizing control is seizing control not just over the rent collection, but over the entirety of the financial management, the books, the records, the decision-making that has to be made. There are properties that have deferred maintenance issues where repairs or some type of capital improvement needs to be made. So all of those things are captured within this bucket that I call control. So seizing control is the objective when I am there at the behest of the secured creditors. Now, when I file for receivership on behalf of a shareholder or a general partner who's not in control, who's unhappy with the folks that are in control, who's unhappy with the performance of the management company that under a contract is operating the property, then the objective is not that much different, because we want to take the so-called bad guys, the bad operator, the bad partner, the substandard management company out of control for precisely the same reason that the secured creditor wants them out of control and out of the picture. So someone who's more responsible, who's better, more skilled, can collect the rents, make sure that they're properly applied, from a budgetary standpoint to the different expenditures that including debt service that the property has, and also to seize control over the books and records, so the management and what happens financially is transparent. So they're not that different.
Okay, great. In a little bit, I'm going to ask you about how we emerge from receivership, but I want to go to Dan for a moment. First, I want to step to the side. Dan, we're March 17th, 2021. We've been having several of these AHOA webinars that have been fantastic. From your analytics side, are we feeling better? Is the market improving? Or can receivers hold in there? And are we seeing better days ahead?
So that's a really good question. I'm an optimist at heart, so I'm going to say yes. Better days are ahead. It's really interesting. Obviously, when the first month, call it after, what was it, March 10th was the anniversary, whatever the anniversary was, mid-March through end of April, were just horrific, mind-boggling, unprecedented. I mean, we've heard all these terms of how the lodging sector was impacted, right? And if you think about it, the fundamental premise of a hotel was very different than other forms of commercial real estate, in that you have daily leasing of guest rooms. And with technology being what it is, the pricing of those guest rooms literally changes by the nanosecond. So in an up market, that's a beautiful thing. In a down market, like we just experienced, it's a horrible thing. And but by the end of April, so call it 30 to 45 days into this, revenue per available room for the sector was down a mind-boggling 80-90% over the prior year. And what's interesting is that prior oh my God moments and big downturns, whether it be 9/11 or the great financial crisis, revenue per available room decreased anywhere between 20 and 25%. And those, when they occurred, were perceived as, wow, mind-boggling, right? Well, 80% compared to 20 to 25% is obviously a hell of a lot worse. And so here we are today, and revenue per available room, actually very nicely, particularly through last summer, the decreases from prior year were the decreases in revenue per available room were decreasing. And so now we've been hovering right around 45-50% decline in revenue per available room compared to last year, pre-COVID. And everything's relative in life, right? That looks good, right? 40% is a hell of a lot better than 80% negative, right? But let's face it, on the grand scheme of things, those are still pretty terrible numbers. So yes, the outlook is brighter. Occupancies, listen, we're going to get back to normal, right? We will get past this pandemic. There will be some other calamity that happens in life. It's just sort of the way life is, right? But in the meantime, people are innately wired to travel, to deal with each other face to face, to break bread. I'm looking at you two gentlemen on the screen, right? And I'm looking at your eyes, but I can't see in your eyes, right? And there's nothing that takes away from personal face-to-face meetings. So travel will definitely come back. The $1 million, the $1 trillion question is, how long will it take? And when do we get back to all-time highs, which were experienced in 2019? It is very interesting that in just the past couple of weeks, I'd say 14 days, and maybe it's because we're going into spring and the sun is higher in the sky, but I will tell you, there's a whole lot of optimism out there. And there's also a tremendous amount of capital dry powder, if you will, sitting on the sidelines, looking for yield. There's talk about inflation on the horizon. Hotels are not only, on a risk-adjusted basis, superior investments when compared with other forms of commercial real estate. If you have any sense of inflation, you want to be invested in hotels because, again, you can reprice rooms continuously, right? Unlike an office building where you have, long-term tenancies. Now they're credit tenancies, right? Unlike a hotel, you don't, right? But you have fixed rents. So that's my take.
Going back, okay, so a hotel by nature is highly local. Pick a town, pick a hotel. The hotel manager is going to know the sports schedules for the local colleges, when prom season is, ups and downs. That hotel has been placed in receivership. LWHA has been appointed. You come in. What are the first couple weeks, days, interim period? How are you learning? How are you trying to improve upon what's going on there?
So, taking off from Emil's earlier description about stepping into the shoes of the owner, I believe is what he said.
Sure.
That really is what it is, right? The owner legally still owns the asset, right? But a receiver comes in and takes complete control so that, yeah, legally the owner owns it, but they have absolutely no say, control, access, decision-making capability, nothing, right? And so when I step into a receivership matter, I'm becoming an owner overnight, right?
Correct.
An owner of an asset that, listen, I understand the sector, right? I get the business. I'm very, dialed into how hotels work. I used to be, in the operations end of the business, right? But there's still a tremendous learning curve to getting into a specific asset and understanding all the minutia of what's going on at the property, right? Emil was talking about, capital expenditures that may be needed. What are the books like? Where are the revenues coming from? Where's the demand coming from? What do the expenses look like? Are they outside of a reasonable range? And if so, what do we need to do to tighten those up? Really doing a deep dive sort of forensic analysis in a very short period of time to embrace an asset and get your arms around it. And, in a very short period of time, getting to know it like you've owned it from day one.
So at the start of the conversation, my premise was HOA members who are facing stress with their properties, and then HOA members who might have opportunities. When you go into a town that you don't know necessarily great, are you looking for wisdom from the town? Are you taking informal polls of what's happening? Is there engagement of HOA members? Or can there be from LWHA?
Oh, absolutely. For sure. There's no question about it. The best way to listen, the internet, there's lots of material out there, right? I think we also know that don't believe everything you hear and necessarily read, right? In order to do sufficient due diligence, absolutely, you need to pound the pavement and talk to anybody and everybody. And I've always been a big believer of coming up with a set of questions, right? And in my humble opinion, if you ask 10 people the same question and you get 9 of the same answers, 7, 8 of the same answers, you probably have a good idea of what's going on, right? So absolutely, there's engagement with the local community. And you're right, the hotel business is a neighborhood street corner business. Always has been, always will be. So I am sometimes amazed at, coming across general managers of hotels and, talking to them and, asking what's going on at the hotel next door. And they're like, oh, well, this is what I heard, this is what I think. And okay, what kind of condition is it in? I don't know. I haven't been in there in about a year. Wait a second. It's right next door and you haven't been in it. So anyway.
Emil, 2 questions related for you. We've talked about receivership as sort of a suspension of the process, trying for the asset to do better. LWHA is engaged as receiver. They've not only stabilized the project, Emil, but they're doing well. They're doing terrifically. Let's say it's starting to pay perform on the debt, underlying debt. How do you emerge from this type of receivership? My next question is going to be LWHA is not engaged and the property continues to do poorly, and what happens? But let's start with the good case first.
All right, well, with a good case, when you reach that, what I would call stabilized mode in receivership, when the property is operating smoothly, is cash flow. I agree, hotels are seasonal, cyclical businesses, but where the cycle is restored to what it should be, occupancy, room rents, maintenance, restoration, as you said, of debt service payment. There will be a time when I think the responsible stakeholders, the receiver, the lenders, will reach a consensus as reasonable people that it is time to end this, that the goal has been achieved. And this is it's not a fixed process like in bankruptcy, which has rigid timelines that you will have 120 days unless the court extends it to file a plan of reorganization. In receivership, everything is more flexible, more fluid, and it's just a rule of reason that is going to govern when you reach the point where the receivership has outlived its usefulness under the good scenario, and it's time to terminate it and to discharge the receiver.
So does the receiver, in a sense, walk away? The original owner debtor come back to the property?
Well, that's a good question. The way it works is that a motion is filed either by the receiver's attorney or by the creditor's, a secured creditor or lender's attorney with the court, asking for the termination of the receivership through an order that discharges the receiver. When the judge enters that order, at that point, the management reverts back and the possession of the property reverts back to the owner, who, as Dan has said, has retained legal title ownership all along. That has never changed, but the possession and the control reverts when that order is entered.
Okay, I'm going to come back to you in one moment, Emil, to ask you about a bad case scenario where it doesn't go well. Dan, is there any liability on the receiver? Are you at risk, but do you face any protests from the owners or other parties, and how do you protect yourself?
That's a great question, and nobody in their right mind would accept the receivership without getting, complete indemnification. Obviously not for criminal conduct, sure, or but otherwise, yes, the court grants indemnification, and unless you do something grossly unreasonable, there is no liability. And it's a good question because, let's face it, a lot of decisions need to get made, right? And I've never met anybody who batted 1,000 on making decisions, right? So there is such a thing as making an educated but turns out to be not such a great decision, right? No liability associated if you've done the right thing and you've done the appropriate due diligence to come up with a logical conclusion. If it turned out that it was not the right conclusion, that's another story.
Great. Emil, a judge had a choice of picking LWHA or its campaign manager, the estate attorney, for reasons that we don't understand, or maybe we do understand perfectly well. The judge picks the estate planning receiver, and the hotel does worse, or doesn't do any better, and can't pay the debt, and is just floundering, and occupancy is tanking, the whole thing. You get the idea. Now what happens?
Well, you can't sue the judge for making a disastrous call.
I'm not talking about liability. I'm
But
talking.
I know what you're talking. I'm getting
Okay.
to it. I was
I'll
just
just sit here.
injecting a note of humor. And actually,
Right.
to Dan's earlier point about whether the receiver has any liability, the receiver doesn't have any liability for two reasons in addition to the indemnification. One is a receiver, even if he's liable for something, okay, like some gross negligence or some very willful conduct, is only liable in their representative capacity. So never liable in an individual capacity. So
Sure.
people like Dan can go to sleep at night because they'll never have individual liability. And in some jurisdictions, you don't even need the indemnification because the law of the jurisdiction says that you're like a judge. You get the judicial immunity, which is absolute. So they don't even have to give you indemnification. You've got it by virtue of what the law is in that state. Maryland, your state, Stephen, is one of those states. Anyway, but to answer your question, there are receiverships that fail, where there is no success. And there are two ways that those end. You can be in a jurisdiction where the judge is very, very focused on his disposition batting average, like in the Eastern District of Virginia Federal Court, which is the rocket docket of all federal courts in the country. There are judges on that court. If you come in with a hotel receivership, it could be a marquee property in Northern Virginia. The judge is going to tell you 60 days. You don't even ask for an extension. If you can wrap up your receivership in 60 days, or go into Chapter 11 if you don't like it, and they mean it. Okay, so they'll force the exit. The other situation is where it's so bad that everyone realizes that we're wasting our time even in a receivership. We're just prolonging maybe a quiet death, or we're really deluding ourselves in having terminal euphoria about something that can only be solved through a sale. And this asset has to be liquidated. And then you either ask the receivership court to authorize it, they may or may not, or you go into Chapter 7 bankruptcy, or in a liquidating Chapter 11.
Okay. Our contact information is below. I'm looking at it, Emil's email. Dan, I guess I'll ask the question, but I'm sort of stating it. Seems to me that a distressed owner, a lender should call you guys early rather than later. Let's start there. Dan, you want to be called earlier rather than later? Does it give you opportunities to help the owner plan, help the lender plan, and make it as smooth as possible?
I mean, I think the logical answer to that is yes. Does that always happen? No. I mean, of course that makes sense. And including probably calling an attorney, calling Emil before you call me. I should be the second call. But absolutely.
Emil, we had a separate session, but it goes to this one about you're facing distress, the dialogue, if you're the debtor owner with the lender. I assume it's still the same thing as you want to try and make those connections. I assume there are also times when it doesn't matter. What's your advice to clients on dealing with the lenders early?
It is never a bad idea to deal with your lenders early. However, we live in a different world than we lived 10, 15 years ago, or the last time that there was a major meltdown in commercial real estate that was nationwide, which went from the third quarter of '89 until sometime through the fourth quarter of '95. And that has to do with the fact that there are two types of lenders. There's your traditional banking lenders or balance sheet lenders, and then there are those lenders called the securitized lenders, or the commercial mortgage-backed securities lenders. And getting the attention, you can't communicate with your lender if you can't get their attention. Okay, that's just a truism that happens, a cliche that happens to be very true. And getting the attention of your balance sheet lender is very easy, especially when their loan is not performing. Okay? They will come to you before you go to them. But even if you were thinking that you're reaching the end of your rope in the sense that you've made the debt service payment for March, but you're not going to be able to make the one for April, it's a good idea, to keep your lender informed of that, so it doesn't come as a total surprise out of the bigger trick. And Dan, please feel free to chime in, is how to get the attention of the other type of lender, because there you're not dealing with a single entity that holds the note. Okay, the note is sold serially to maybe 100 people, maybe more, and there is a special servicer, okay, who's the representative of the fractional note or securitized note holder interest, and there to get them to actually communicate with you and to start dealing with you in an effective manner is an art form. Okay, it is not science. It is very, very difficult, even after you stop paying your debt service, before you're going to get someone's attention there. So you need legal advice as to both, but when it comes to the securitized lender, it's a different world altogether.
Okay, I'm going to shift to Dan in a moment. Kristen, do we have any questions from attendees? While we're waiting for.
We do have some questions.
Okay, hold on 1 second. I'm going to go with Dan first, and then we'll come back to the question.
No
Dan's same exact question, but CMBS. Anything to add on what Emil said about the harder ones with the CMBS lenders?
Yeah, I mean, I would just elaborate a little bit further.
Sure.
Well, first of all, I agree with everything Emil said, but just elaborate a little bit further on CMBS. At the end of the day, the notes are carved up into bonds, and there are different tranche holders who own those bonds, from the least risky to the most risky. And an entity called a master servicer handles the incoming debt payments and handles the loan, if you will, right? When things go bad, the master can't do anything. All the master can do is send it over to a special servicer. So that's the first step. You got to get through the master, go into special servicing. It's interesting, this downturn, and frankly, the last downturn as well, even though this one even more so because it was so sudden and unexpected, the special servicers just got inundated with problem situations. Think about it, 30 days, got inundated. And they weren't staffed up. Hotels are a unique animal. We talked about that. They don't want to take ownership, right? So talk about the proverbial kicking the can down the street. I mean, there's been an awful lot of that going on within the CMBS world at this point. And just, to confirm what Emil was saying, even when you get a hold of the special, right? The REMIC rules, which govern CMBS, really create a limitation of what actually can be done in terms of a workout. Unlike a balance sheet lender, has free reign to decide to modify or not, and how and what modification. So CMBS and balance sheet lending are two completely different animals. And I think it's fair to say that at this day and age, receivership matters relative to hotels. The great majority of it is tied to CMBS debt, not the balance sheet debt.
Great. Kristen, questions for us?
Yes, a couple of questions came in. The first one says, who determines who the receivership is?
Emil, who gets named as receiver? Who has the right to name? Is it the judge?
It is ultimately always in the total discretion of the judge. However, one of the things, appointment of a receiver and who and how you go about it is an art form because it is so court specific. So unless you know your court, you could be cruising for some very unintended consequences. For instance, let me give you an example. I have never had to go to New York City to appoint a receiver for anything, but recently I very seriously started with toying with the idea of appointing a receiver over a foundation. There's no real estate, there's no room revenue, there are other types of assets. And it was very important for me to make sure that I don't get a total stranger. In other words, will the courts in the New York City State Court judges, will they seriously entertain nominations? If I go with the petition and the judge says he's willing to grant it, will he or she say that if I mention Mr. Lesser as a candidate, that unless Mr. Lesser turns out to be some totally objectionable individual, usually you get your way in a court where that is the practice. Well, in New York City, that's not the practice. The judges still are old school. They appoint their friends, they appoint the brother-in-law's golf buddy, things like that. So I scratched the idea. I told my client, we are going to invite the law of unintended consequences. We may get a total stranger and you will just have to live with that stranger. So we decided not to. We decided to go a different route. Now, in the jurisdictions that I've gone for receivership, Maryland, District of Columbia, Virginia, the courts will listen to nominations. Okay, often the receivership is done by temporary restraining order. In some jurisdictions, like in Maryland and in DC, to appoint a receiver, you have to file a complaint in court and file a motion for a temporary restraining order, and you go and see a duty judge. And sometimes it's done in chambers, sometimes the other side's not even there. They'll ask you, who do you have in mind? If you come up with a respectable name that the judge would have no reason to have any objection to, you've got it. Okay, but that's not true in New York City. I have had one situation in Northern Virginia where I did file for a receivership for a mortgage company that had mortgages on hotels. And I proposed someone, one of the other lenders in the case had someone else that they wanted, and the judge scheduled a hearing where he took testimony from the two candidates and then decided to appoint my candidate. But it does happen that a judge will disagree with a choice or will not listen to what I, as the attorney for the petitioning creditors, have to say. It has happened.
I'd like to just add, if you don't mind,
Yeah, go ahead,
I've actually seen a situation where exactly what Emil described happened, where the judge insisted on appointing a certain candidate, and the lender basically withdrew the application within that jurisdiction and went to another jurisdiction to refile, and more friendly jurisdiction to, as Emil said, if the candidate is a reasonable candidate, why say no? One thing I'd also like to just point out relative to hotels, what I'm seeing this go around in this downturn is, in years past, vis-a-vis hotels, you had hotel management companies, so day-to-day operators, being appointed as receiver and then appointing themselves as day-to-day operator. So they held both functions. This go around, most of the special services don't want the same party doing both. They want to bifurcate. They want a receiver. They want say on who the operator is going to be, right? But they want a separate operator, right? And if you think about your question earlier, if things aren't working out for some reason, right, it may not be because of the receiver. It could be because of the operator. It could be because of the receiver as well, or just the receiver, right? But if you think about it, if you have it broken up into two separate entities, first of all, you have checks and balances, right? Second of all, if one or the other is not performing, right, why get rid of the baby and the bathwater, right? Just wanted to bring that up.
Great, perfect. Kristen, any other questions?
Yes. The next one says, if you go into receivership, does that stop interest from occurring?
Oh, that's a good question. Emil, do you want to take that one?
Legally, this is one area where receivership is very, very different than bankruptcy. Yeah, the receivership doesn't change anything about the loan except the fact that you cannot enforce you cannot proceed to foreclosure or to sell the asset without leave of court. But accrual of interest continues. The clock continues to run.
Frankly, it's actually even worse, because if you've defaulted, in many of these instruments, there are provisions that default interest rates are much, much higher than the stipulated rate if you're paying on time. So it definitely continues. The interest component does not go away.
No.
Kristen, another question?
Mm-hmm. Does the receivership have any say in how the hotel is being managed?
Dan?
You don't legally own the asset, but you're the owner. So the answer to that question is yes, absolutely. You own the hotel, philosophically, not legally, right? So you have a fiduciary responsibility of making sure that a day-to-day manager, operator, what have you, who you feel comfortable with, and obviously the lender has input into this as well, right? But ultimately, the final decision is with the receiver. Emil alluded to this in the very beginning. A receiver is an agent of the court, right? And the court has the final say.
Kristen, do we have one more question?
Yeah. And then the last question says, how do you determine if it's better to declare bankruptcy or go into a receivership?
Start with Emil, and then we'll go to Dan on that one.
Okay, in other words, how do you make that fateful choice whether it's one or the other? And this is from an owner's perspective, I gather.
That's exactly what I was thinking. From whose perspective do we talk?
Right. The perspective matters a great deal. Okay, an owner. If you are facing imminent foreclosure and you've exhausted everything with the lender, and you know that your lender doesn't see the world the way you do as an owner, and will just fight you at every step of the way because they want to recover the asset, you are better off going into Chapter 11, okay, with that asset. And unless your asset is so troubled and so depleted in its ability to generate cash, where all you're doing by going into Chapter 11 is accomplishing two things, neither one of which is a worthwhile goal. One is to pay some lawyer a big retainer because Chapter 11 is expensive, and to be liquidated through Chapter 11, which adds more expense because there are cheaper ways of liquidating. So if your asset is so damaged that you're at, let's say, 30% or less occupancy, you're not meeting your break-even points, the market that you're in is saturated with a glut of similar non-performing marginal properties, and Chapter 11 at that point is going to do very little for you except your building cost.
Okay, Dan, any other analysis?
Yeah, I mean, what I would add is, I mean, again, to Emil's first question, from whose perspective, right? So, listen, you know, this go around, there are no shortage of folks who are dealing with troubled assets, no fault of their own, right? Let's face it, you know, COVID was thrown upon us, right? And nobody had a choice in this matter. Nobody expected it. Nobody could plan for something like this, right? So a lot of distress that exists in the hotel world today is not because of overbuilding and overspending and all these negative things that in the past have caused tremendous downturns. You know, there are no shortage of folks who, excuse me, now are dealing with distressed assets, but were purchased, you know, 5 years ago, 6 years ago, and refinanced once, twice. And at this point, it's like, okay, you know, you got your money out twice, right? It's a troubled asset because of the market. It needs a renovation. You know what? I'm done. You know, take it back, right? And so then the lender is going to say, well, okay, great. We're not taking title. We're going to appoint a receiver, right? To Emil's point, the only reason you're gonna declare Chapter 11 and spend the time and the money, because he's 100% right, that's an expensive proposition, is if you really believe that there is an opportunity to turn things around and it makes economic sense for you, right? If you've already taken your money out twice in a deal, why wouldn't you just move on to the next thing instead of, you know, fighting, you know, to do it one more time at the same property? So anyway, I hope that you know, the last thing I would put out there too is that, you know, there are investment platforms out there that invest in all sorts of assets, including commercial real estate, and then within commercial real estate, lodging, right? And you know, there are some groups who, you know, they get to the point where, you know what, we've been there, we've done that, we're done, right? We're going into some other sector now, and lender, you know, sorry it didn't work out, but, you know, here are the keys, basically, right? And again, a lender, for all sorts of reasons, may not want to take title, and in which case they will ask the borrower to cooperate and allow them to put a receiver in and ask for the owner, the legal owner, to be cooperative with the receiver.
Great. We're at the end. I'd like to add first my last comments, and then Emil, and then Dan. Any final thoughts you want to add? Lessons learned from this horrible pandemic? I'll start first. Emil and I have a good friend and colleague who says that we can think our way through anything. He said that in 2006, and I think he's right. It's been really tough. I've been amazed at the collegiality in the industry. Everyone's been fighting it out and seem to be doing okay. I would note Arnie Sorensen passed away, and his legacy is deep. I know Emil lived near Arnie, and it's tough for all of us. Emil, I'll give you lessons learned. Anything you want to add, and then you, Dan.
Well, you know what, the main lesson, honestly, that I have learned is since March of last year, when the world changed, is that we as professionals, people like Dan, myself, the people who are professionals dealing with commercial real estate, including hotels, that we cannot rely on the tools that we were using 10 years ago or 25 years ago. Like I said, when I drew the distinction between the securitized lenders and the balance sheet lenders, it's a new ballgame. It's a new reality. And you cannot advise your clients or your friends to do what, you know, worked in another era. Even though that era may not have been that long ago, it doesn't work. You have to feel your way through the new reality, learn what plays in Peoria, so to speak. And on the issue of that you asked earlier, or that someone asked earlier, one of the participants, when do you decide whether you're going receivership or an 11? I think that Chapter 11 ought to be a last resort because it's expensive. And I use a term that I adopted from medicine, even though I'm not a physician. And the term is vital signs. If the property, the hotel property, has the vital signs, then it is a candidate for Chapter 11, because what Mr. Lesser said is very true, that a property that has those vital signs may be salvageable. Okay, the salvage may be an infusion of equity, if not from the current owners, then maybe from some outside equity source, or some concession from the lender, or a combination of the two. But if the vital signs are not there, then you're better off going into receivership, which is less costly, and hoping that that somehow a miracle will happen to your property.
Dan Lesser, last thoughts, including maybe the analytics that you are finding encouraging?
Sure. I think the initial question was lessons learned, and I will respond with not necessarily a lesson learned, but something that I've always been very tuned into, and this downturn has only validated my thinking in terms of hotels are fundamentally long-term investments, right? Because of the built-in volatility of occupancy and room rates, we talked about that. It can be a very dicey proposition if somebody underwrites assuming a 3, 4, 5-year holding period, right? Think about anybody who bought a hotel and closed in December, January, or February of this year. 19 and 20. The prognosticators are saying it's going to be till 2024, 2025 before the sector gets back to 19. So if you closed on a hotel in December of 19 or January of 20, right, on the premise of holding it for 3 to 5 years, that's going to be a dicey proposition. And at best, you might preserve your capital, never mind make money, right? Whereas those who underwrite, understanding that hotels, again, are fundamentally long-term assets, and they underwrite for, frankly, my humble opinion is a minimum of 10 years, right? You have to be ready, willing, and able when you invest in a hotel to hold on to it for at least 10 years. Doesn't mean that if an opportunity bubbles up to facilitate a capital event, a sale, a refinancing, bringing in a partner, what have you, doesn't mean you won't do it, right? You might do it in year 1, you might do it in 2, 3, right? If it makes sense and you can bake in some gains, you might very well do that. But again, I go back to the notion of somebody who bought, and closed just before COVID, right? They better be prepared to hold on to for at least 10 years. And then the last thing I would say is one of my favorite quotations is from Winston Churchill. And he said, if you're going through hell, keep going.
Great. Dan, thank you. Great friendship, great advisor to me. Emil, the same. Thank you so much. Kristen, thanks for inviting us.
Thank you.
Again, it's just a wonderful group for us.
Yeah, thank you again, Stephen, Emil, and Daniel, along with American University, Washington College of Law, L&W Hospitality Advisors, and Carlton Fields for this informative webinar for all our members that joined us today. We hope you have a wonderful day and join us for future webinars and events. Thank you, gentlemen.
All right. Thank you, Kristen.
Bye-bye.
Thank you.